What's the process for me to settle my personal injury claim or accident claim? Well, basically, what you do, if you settle a case, you want to know all the facts. You don't want to settle the case and then have surgery the next week and not be compensated for that. So when you have all of your damages known, your medical expenses, wage loss expenses, what you think your pain and suffering damages should be, emotional distress, past and future, you're in a position to settle the claim. Your lawyer or representative should have gotten all of that information, given it to the adjuster. And then as soon as you're done treating and all that evidence is garnered and you know the full extent of your damages, you typically make a demand to the insurance company and see if they want to settle the claim. They're going to start low. We start a little high. But pretty soon I talk to the claims adjusters, email, communicate with them, talk to them about how high they're going to go in the claim. I want to know, how high are you going to pay my client so I can make a decision and visit with my client about whether we accept that and think that that's a fair amount to compensate my client, or if we need to file a lawsuit and litigate it because you're not being fair to us and we need to keep pushing you, keep prodding you until you realize or appreciate the wisdom of our position. Sometimes insurance companies are just never going to settle cases. They have a tactic where they lowball people in the beginning. They don't offer them a lot. They do it to lawyers. They do it to they do it to injured claimants, and they figure X percentage of them are going to take the low money. We don't do that at Burger Law. So what we often do, we file a lot of lawsuits. We often encounter low offers, that kind of stuff, where we have to file lawsuits and litigate the cases so that they go to lawyers and they go to claim agents who know that Burger's going to try the case, or we better pay the full value of the case, not 50%, 60%, 70%, and try to get rid of it on the cheap. No, we want to get full compensation for your injuries. All lawyers should. I certainly work hard to do so. That's one of my mantras is I hate bullies and I hate and I don't like bad insurance companies and corporations. Not all. There's great insurance companies. There's great claim agents. I'm friends with them. I have represented many. But there's also this tactic of knowing that claimants are risk averse and they don't want to take that risk, so they'll try to throw a little money at you and see if you'll go away and settle and sign a release. So that's when you want to settle the case. The process is once you agree on a number, they're going to prepare a release, and that you have to sign a release forever releasing your claim for everything in the past and in the future, and know that this is the only recovery you can have, and you acknowledge it and you release that for a certain sum of money. And then when we get the check. When we get the check, we put it in our trust account, which is an account that I hold for my clients, and I hold that money in trust. Out of that trust account, we often have medical liens or requests from health insurance companies or other medical providers that want to be paid. I've done whole videos on reducing liens. I teach other lawyers how to reduce liens. If you go on my website on burgerlaw.com, I have memos in our to lawyer section. I teach other people how to reduce liens, because it's not just how much you get in the front end of the settlement, but how much you get in your pocket at the end of the settlement that really matters. So we reduce the liens, we pay the liens out, we pay our expenses, we pay our fee, and the rest go to the client. We also provide a letter and a settlement statement outlining everything we did with the money to the nickel, to the penny. And so you'll know at the end of a case how much the settlement was for, what the attorney's fees, the expenses were, and what went to the lien holders, and how much you get in your pocket. Personal injury cases and personal injury settlements are tax-free. Do not pay taxes on them. Don't even report them on your tax return. You do not need to. And the other thing on expenses are, people hear expenses, oh, you're going to put in a bunch of stuff. No, we're not. No, we only put in expenses or money that we pay out of our pocket, that I have written a check from my personal operating account. And I'm cheap with my money. You can ask my family, my kids. And I'm cheap with my clients' money. So it's really important that I not put money into a case or invest money in expenses of the case unless that return is worth it. So we don't put money into depositions and experts and records and things unless that's going to increase the value of the case or to our best expectations. So we're really careful on expenses. We're really low on expenses. I don't hide attorney's fees and expenses or anything like that. And we're transparent. It's not my file, it's your file. So you can see your expenses at any time. We've never had a problem with it with our clients. And then you get your check, you sign the release, you give it back, you get your check, you cash your check. And if it's really high numbers in settlements, I also try to assist clients with making sure they keep that money to last for a long time. Because if you're getting a one-time recovery for lifetime damages, you want to make sure that those damages last you a lifetime. And there's different investment devices or other things that sometimes I tell, I'm not an investment advisor, I don't tell that, but I say, listen, you ought to go do this, that, or the other thing. They get their own people and they do it. Thank you.